Well, thank you, Eric. So I wrote major sections of the complaint along with Peter Adler. And I'm here to talk a little bit about some of the legal and political realities I think our movement's going to have to face in the coming years and months. And this morning we watched a great talk from Che about how there's a lot of overlap actually between very differing groups. And we have a lot of common ground with them, but there's actually a few, I'd say, pinch points that we have to be skeptical of and careful of and cognizant of as we tailor our strategy. And so I'm a second-year law student. I'm about halfway through. I've had many lessons, chances to learn a lot of lessons about politics and law. For example, I had the chance to testify in front of the Virginia Senate for a bipartisan education bill. And generally, I've just been able to attend lots of talks on campus and really have my finger on the pulse of topical issues in politics and the law. And so one lesson I learned that really has stuck with me was from this communications director. He was the communications director for 2 different Virginia governors. And so what he said was, an effective message is not the best thing you think you can say. Rather, it's the best thing your audience needs to hear to achieve your desired outcome. And importantly, he said, you may loathe what you have to say to your audience in order to get that outcome, right? This is about being politically savvy, right? This is about being strategic. It's not about having the most ideologically pure position in every scenario, right? It's about doing what you have to do to win. And from this salient message, I think I've derived 3 basic principles of successful advocacy. So the first is we need to be ready to tailor our strategy, right? Be actively conscious of who we're speaking to and using what rhetoric with whom, and what those people's goals and motivations are, and where they intersect with ours and where they diverge from ours. Second, we need to be sure that we are pursuing incremental wins, right? It's not necessarily the best political strategy to just go for an across-the-board ban right away, right? The work that Anthony Squadro is doing with defunding circumcision is a very important step, right? It's an incremental step. And third, we want to learn to live to fight another day, and I think Eric has some experience with that. You don't want to be fighting your hardest battles on day one if that means you're giving up all the low-hanging fruit you could be pursuing, right? And so there's this corollary to the previous quote, that activists are often willing to sink their initiatives over messaging, right? We don't want to sink our initiative, right? We want this movement to take off and be successful in the next few years. So that raises the question, what is our desired outcome? I think a lot of people in this room would say our desired outcome is to ban circumcision. Well, unfortunately, I'm here to tell you that that should not be our desired outcome right now. Instead, I think we should have our desired outcome to be denormalizing circumcision, because really what matters is that the conduct stops happening, right? It doesn't matter if circumcision is illegal if no one does it. That's really our goal. And so why do I think we shouldn't try to ban it, right? If we look at the numbers, the reasons parents circumcise is overwhelmingly not anything to do with religion, right? It's about only 13% of parents say religion is very important or extremely important in their decision. And so why would we be going after this minority of cases when we're leaving on the table all kinds of other reasons that are more easily attacked in a politically feasible way? And so I present to you 2 visions of how the future of circumcision rates could go based on our political strategy. So the first situation is where we somehow, by a miracle, RFK Jr. descends from heaven and gives us some kind of ban on circumcision, right? He says it's not medically necessary, everyone agrees. That's not going to happen. What's more likely going to happen is that over time, not as a quick time horizon as we'd like, circumcision falls out of favor, right? And it goes back to being a minority religious-only practice like it once was just a couple centuries ago, a couple decades ago, and is right now in most of the world. And so we'd like to get to a 0% circumcision rate, but I think right now our goal should be getting to the 13.6% roughly of religiously motivated circumcision, right? And so on the left, we have a politically unfeasible option, which would be great, but get it out of your minds because it's probably not going to happen in the near future in this country. And so I want to raise a couple key issues that I think that we diverge from a lot of these mainstream political parties in regard to circumcision, right? And these 3 issues have legal and political dimensions. And so the first is parental rights. What can parents decide for their kids? And in this issue, we actually diverge a lot from liberal progressives, especially transgender activists. The second is medical necessity, which is a very important aspect of what Anthony Squadra is doing with defunding circumcision, because Medicaid is supposed to only cover medically necessary procedures. And here again, we diverge from liberals and progressives who want publicly funded health care. And then, of course, the elephant in the room is religious rights. And this feeds into the reason why I think pursuing a ban is not a good idea right now. And of course, conservatives, even up to the Supreme Court, are actually looking to expand religious rights rather than contract them. So let's start with parental rights, which actually I think is probably the best issue of the three for us. So what does the Supreme Court have to say about parental rights? The Supreme Court has said that parents do have broad powers. It's a very traditional, fundamental right of parents to be able to decide what kind of medical care their children get and receive. And this is what, let's say what the Supreme Court has said parental rights do not cover. Parental rights are not unlimited in terms of things to do with the child's welfare, right? And so the state has a role in limiting what parents can decide for their kids. And this is where we get, things like compulsory education, right? You might not have to send your kids to public school, but if you're going to not send them, you have to do private schooling or you have to do a homeschooling, right? So the state has power to limit parental control and autonomy over their kids, right? So that's a legal reality. It's actually quite good for us, right? Circumcision is harmful for children, and so parents should not be able to make a choice to circumcise their kids. The problem with that is that politically, there's tension here with specifically the transgender movement and liberal progressives who want to actually expand and strengthen parental rights. And so from this recent law review article, diminishing parental rights can also harm trans children and their families. And in fact, this article even mentions male circumcision as something that's within the realm of what parents can decide for kids. Right? There's no consensus among experts that the law properly allows parents to make myriad decisions about child rearing. And so that leads us into the next kind of political friction we run into, which is medical necessity. So I'm sure many of you are very familiar with this kind of chart where you see there's a correlation between whether circumcision is funded by Medicaid and the rates. And of course, here in Oregon, since 1994, it's not been funded, and the rates some of the lowest in the country. And so states have varying definitions of what is and what is not medically necessary. And so this is going to make challenging this kind of difficult because you have to tailor your strategy to each state. So for example, in Oregon, medically necessary procedures involve prevention, diagnosis, or treatment of a disease, condition, disorder, yada, yada, yada. Meanwhile, in my home state of Virginia, you see a very different definition, right, which presents its own challenges. And actually, there's some language here that's good for us. A service is not medically necessary if regarded by the medical profession as experimental or unacceptable. And so this is exactly what we want to argue, that male circumcision is unacceptable, and so therefore it should not be covered by Medicaid. But again, the problem is this is in tension with the political position of transgender activists, right? Transgender activists want a broader definition of medical necessity. For example, from this recent case in New York, plaintiffs were seeking for these, by definition, cosmetic procedures to be covered by the state Medicaid plan, but they weren't covered. And so it seems unlikely that people with this kind of motivation politically are going to turn around and say, well, no, we should shrink the universe of procedures that are medically necessary, right? Because if these procedures, which on their face are pretty cosmetic, electrolysis, hair removal, if those are covered, then surely male circumcision, at least if you believe the so-called health benefits, would also be covered, right? So there is, of course, a way to reconcile these views, but there is also a tension there. And then also, maybe along the more traditional liberal wing of the left-leaning parties, it's the idea of health equity. And the reason we want to broaden the definition of medical necessity, or at least keep it broad, is because we want everyone to have equal access to publicly funded health care. And so this is Paige Boschman of New Hampshire that Anthony Squadra just talked about, testifying 2 years in a row against a bill to defund circumcision from Medicaid. 2 years in a row. And why did she say this? Well, she tells us why she said it, and she says that, why do we think it's okay to take it away in a discriminatory way? So for Democrats, it seems that health equity is a more important party line than protecting the health of kids. And as we saw in New Hampshire just a couple weeks ago on the House vote, it was all on party lines, and it was all Democrats mostly voting against the bill, including Ms. Boschman. And so that brings us to religious rights, which is really the reason underlying this talk of why we should not be pursuing a ban across the board. Okay, so what does the US Constitution have to say about religious rights? Well, it actually doesn't say all that much. There's the Free Exercise Clause, which is the one we're interested in. Congress shall not make any law prohibiting the free exercise of religion. Right? And states all have, generally have their own free exercise clause, an analog of it, and generally they're interpreted a similar way. And so we'll focus on the federal Equal Protection Clause for now. And so a very important case in equal protection actually arose right here in Portland, Oregon. In this case, Employment Division v. Smith. So this is Al Smith. He was a member of the Native American Church. And there's a ceremony in the Native American Church, a very central and important ceremony that involves ingestion of a hallucinogenic cactus, peyote. And basically Smith partook in this ceremony, this religious ceremony. But at the time, peyote was illegal in Oregon as a Schedule I substance, right? And so as a result, Smith was fired from his job, and he was denied employment benefits because he broke the law. And so what did the Supreme Court have to say about this? Well, an opinion by Justice Scalia, who is known as a very conservative judge, one of the leaders of the legal conservative movement, he actually ruled against Smith and against religious rights. He said, "We have never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate." Right? So religion was no excuse. So the standard we got from Smith was that a neutral and generally applicable law is generally not problematic under the Constitution, under the Free Exercise Clause. And this sounds good for us because that would mean if we were to pass a law that bans circumcision for everyone, religious or not, that would be consistent with the Constitution. It just happens to incidentally burden a religious practice, a religious ceremony. Well, there's a couple wrinkles to this. Basically, Congress did not like this ruling, and they tried to overturn the ruling with the statute, the Religious Freedom Restoration Act of 1993. This was a bipartisan act. You see President Clinton signing this. And it sought to return to the pre-Smith status quo so that every single law, if it just accidentally burdens religion, is subject to this high bar of scrutiny, strict scrutiny, which basically means if you're a government that's trying to pass a law that happens to burden religion, you're kind of dead in the water, right? You have to come up with a really compelling justification of why this law matters. There's another wrinkle. The Religious Freedom Restoration Act itself was declared unconstitutional by the Supreme Court in 1997, as applied to the states. So that means on the federal level, the RFRA still applies. So then again, you might think, well, if it's unconstitutional as to the states, well, what's the problem then? We can just pass state laws that are generally applicable that happen to ban circumcision, and there's no problem. Well, there is a problem. States thought the RFRA was a good idea, and so they passed their own. Right? And so that it's a law in 32 states that generally applicable laws that incidentally burden a religion are subject to strict scrutiny, right? This high bar, really hard to pass bar. And that leaves us with only 18 states where it's politically feasible and legally feasible to pass a law that's generally applicable that burdens religion. And as you notice, Oregon is one of the states, and that's why one of the reasons we're here in Oregon. And so that's the state of the law as it stands right now. However, the law is moving in a direction that's actually counter to what we want. It's going to be moving in a direction that's expanding religious rights, such that maybe even in these 18 states, they're subject to the high bar of strict scrutiny. And so this is Justice Samuel Alito, who is still on the Supreme Court. Of course, Justice Scalia died in 2016. And so Alito has been very adamant about overturning Smith and returning to a regime where there is always strict scrutiny for laws, even if they only incidentally burden religion. And he's actually spoken. He's one of the few times I've found in my research that the Supreme Court has spoken on male circumcision. And he's basically signaled that suppose a jurisdiction in this country, following the recommendations of medical associations in Europe, ban the circumcision of infants. This would be allowed by Smith, and he says this is a problem because it would prohibit a religious right, right, RITE. And so it seems that the law is moving in a direction that would be less favorable, even less favorable than it already is, to a ban for circumcision. And that's really why I think it's not within our best interest as a movement to be pursuing a ban across the board. And if we look at the experience in Europe, it would be really a world first if the United States were the first to lead a radical social change like this one, right? Circumcision is not illegal in any country in the world, right? In Germany in 2012, of course, you are all probably familiar with the 2012 court decision that was summarily quickly overturned by a law that re-legalized circumcision for religious reasons. And more recently, in 2018 in Iceland, a similar proposal was basically shot down from international criticism, a strongly worded letter from the Anti-Defamation League. And so if these countries can't successfully achieve a ban on circumcision, what hope do we have in the United States? And so maybe we can modify our desired outcome, right? While it might not be politically feasible to pursue a ban, it could be politically feasible to pursue a ban subject to exemption for bona fide religious belief. And that would mean we would get back to this status quo whereby circumcision is a minority religious only practice, right? And because of that, we will have built up all of this momentum, social momentum and social pressure to make circumcision not normal. And what that can hopefully lead to is what I would like to call religious self-reform. And this is what we are talking about when we're saying we want to open a dialogue with the religious leaders to reconsider some of their long-standing positions. And it's not without precedent for religions to reform their practices, especially in regards to genital cutting of children. So I'm sure many of you are familiar with this practice of metzitzah b'peh. It's come to be characterized as a minority practice even within Judaism itself, right? So in metzitzah b'peh, the practitioner removes the baby's foreskin and then sucks blood away from the wound to clean it. Of course, this is problematic for many reasons, many health reasons. Children have died from herpes infections. And so it's come to be characterized by as a practice only used by a section of the ultra-Orthodox Jewish community, right? It's disappearing within Judaism itself, and the religion is reforming itself. But you see, this has not always been Judaism's stance on metzitzah b'peh. Metzitzah b'peh was considered a mandatory part of the bris ceremony, right? Any moil who does not perform metzitzah should be removed from his position. Fast forward to the mid-19th century in continental Europe, where the Jewish reform movement was taking off. It was then ruled that metzitzah is not a mandatory part of the ritual, and that the mitzvah is completed even in the absence of metzitzah b'peh. And now if we go to the 21st century, it's being asked whether it should be jettisoned from the religion entirely. So of course, we don't want a 1,000-year time span to get rid of circumcision from 2025. But what we do want is reform from the religion within, right? Because what we see sometimes is when a religion is persecuted and pressured and with legal force, that actually can strengthen the resolve to continue practices and more people become, within the religion, become adherent to those practices. And that's not what we want. That's the opposite of what we want. We would like to motivate the religion to reform itself on its own terms. And, there's great precedent for this within Judaism. In fact, in New York City, the New York City Health Authority has, pressured Orthodox communities to reconsider their positions on metzitzah. And then internationally speaking, if we look over to Islam, Islam has successfully undergone a revolution of genital cutting policy with regards to FGM. And so this is a chart of the four main schools of Sunni jurisprudence and their stances on the permissibility and obligatoriness of genital cutting for males and females. And as we can see, all the four schools seem to agree that genital cutting on females is at least permissible, if not mandatory. And so this did not stop a religious leader in Egypt, the Grand Mufti of Egypt, from issuing a religious ruling, a religious fatwa, that basically said that FGM is inconsistent with the faith of Islam. And he said that he called for a total ban on the practice in all Muslim countries, despite the fact that many Muslims genuinely believed that it's a permissible, if not obligatory, part of Islam. And in doing this, he recognized that Islam is, without a doubt, a religion that adapts and develops to the changing conditions of the world and the state of scientific knowledge. And so I think there is a lot of room here that if you put enough international political pressure, human rights organizations coming together and speaking with religious leaders and motivating them to reconsider their practices that have gone back thousands of years, there is actually room for change. But the thing is, if we're back in a world where it's not a religious-only practice, there is no political and social motivation and pressure for the groups to change. Why would they change? So in conclusion, we looked at basically 3 pinch points where our movement runs and butts heads with other movements, right? We considered 2 possible paths that our movement can take, and I suggest we take the denormalization route, whereby we build up all kinds of political pressure, and that could hopefully motivate religious self-reform when it gets to this minority position. Again, we talked about what makes an effective message, right? And the fact that we need to be politically strategic. We need to be thinking, smartly and deftly about who we're talking to and what their goals and motivations are. And I present to you these 3 ideas and principles that I think you should keep in mind as you go forward in intact advocacy. And remember that activists are often willing to sink their initiatives over messaging. That's not what we want to do here.